Board is now in session.
Good morning. Thanks.
Morning.
Please be seated. We're here for oral argument in Silverdove versus Greenbank, CV21 0215. Good morning. As you know that we record and live stream these arguments, so before you begin, if you'd give your name and the name of the client you're representing before you begin. You'll each have 20 minutes to make your arguments. Although you're not required to use all of your time, we do require that you keep track of your own time, and the clocks on the podium will tell you what your remaining minutes are. Please keep in mind that we have read the briefing, studied the record, and discussed your case in conference. And with that said, counsel, you may proceed.
Thank you very much, Your Honor, and may it please the court, Rob Royal, appearing on behalf of Appellant Silverdove. This case presents the opportunity for this court to examine a settlement agreement that was entered into and apply contract interpretation law that's been set out quite clearly, primarily in the Taylor case. At issue here is really whether to support the plain meaning of the terms set forth in that agreement or the later undisclosed intent of Mr. Greenbank varying the terms of the agreement. The law in this case involving settlement agreements supports the position that appellant is asserting here, applying the basic test beginning with the objective intent. I think it's a little concerning that if we stray too far beyond, in this kind of case, the clear meaning and involving a settlement agreement beyond the objective intent here and support the other side in an undisclosed intent, we're starting to approach things that may be concerning. Like, does red really mean red? Does all investments really mean all investments? It's a concern because of not applying the agreement.
The reason that the question, does investments mean all investments, is because in paragraph 8, it refers to investments and other assets, and says investments, parentheses, the investments, close parentheses, and other assets, but then paragraph 9, when it talks about the repayment plan, only speaks to capital I investments and leaves off other assets. So isn't the problem we have now the problem that was made in the drafting, that it is unclear, that there is some room for some interpretation of why other assets would be taken away from what investments means, and then only investments would be triggered to having to pay the 50%.
Well, they are in separate paragraphs, and I do disagree with that point, because where we came into this proceeding is examining paragraph 8 that talks about all of Greenbank's investments. That's one thing, and other assets, because assets may exist.
Right, but you're the ones who put the term investments after the word investment in parentheses with a capital I, and after that put and other assets. And when we get to paragraph 9, which is the paragraph that obligates him to pay 50%, it only speaks to the capital I investments, which I have to take to mean excludes whatever anyone considered other assets from his obligation to repay funds that he receives from those investments.
Well, I think you bring up a good point that we can separately look at investments as defined versus other assets. Investments are producing income to Mr. Greenbank in this case, and the purpose of Silverdove and Bonnie, the primary person involved, is I don't know what all your investments are and what they're spewing off, so I'd like to know that. And in addition, like any other creditor, it's always good to know what the assets are besides the investments and income coming in, like bank accounts, for example. That might be one situation that puts us apart.
Are you saying that she did not know about ERPSP? She did.
She did know about that, but there could be other investments.
Right, but couldn't she have asked for his affidavit of his investments prior to entering into the agreement, especially since, given their relationship and the concession that she did know about this particular asset or investment or however you want to call it, to make sure that he was fully disclosing what they were. I mean, I assume that the affidavit of his investments came after the parties entered into the agreement?
Yes, it did. I mean, it had to be an integral part of the agreement because it was a continuing obligation as investments may change over time.
Right, but she saw immediately then that the affidavit did not include a known asset that she knew he had, And wasn't that a trigger point before that was back in 2013. They re-entered things they had something happen in 2015, but she knew as soon as he turned in that list that he wasn't compliant, that there was an asset, or as you call, an investment that wasn't listed on his affidavit. What are we to do with that? That she both had knowledge of that investment, it wasn't included on an affidavit that was provided to her, and here we sit now. What should we do with those facts as to the implication for your client?
Well, you're applying a little bit of a hindsight test, which I don't disagree about, but we also go back to the time of contracting, and a person is sitting that does have some knowledge about this, and whether it still exists or not is always not known to her. And so she must rely upon the truthfulness of an affidavit that's being given to show at that point in time a complete listing of Mr. Greenbank's investments and his other assets, and then timely supplement that so there's an awareness, a communication to fulfill the terms of the settlement agreement that she assumes are going to be truthfully set forth, materially set forth, and applying the common meaning as to the word investments.
Right, but this wasn't an asset that was a stock that could easily have been sold. I mean, if she knew that this asset existed, then she also knew the type of asset it was, which was something to generate retirement income for that purpose, because she had a similar setup with Silverdove, correct? That she had a company that had a defined benefit plan that it owned. So she knew the nature of that asset. And to say, well, she has to rely on him to determine whether that asset still exists or not, it's not as if he sold Apple stock and she's thinking, okay, well, it's sold, it doesn't exist anymore. I mean, having knowledge of what that asset was certainly gave her even more notice that it should have appeared on that affidavit.
Well, in addition, you have to look at what she knew at the time, and then yes, she can know the plan exists, but she has no idea how well it's doing, if it's spinning off income, whether it will generate money that half should go to her or not. And so there's a strong reliance, and there has to be, for Bonnie to see what that affidavit's going to say and rely upon it in order to understand what might be coming her way. And she goes into this thing expecting that all investments mean all investments. Nobody says anything different. And this is the secretive or undisclosed intent that I don't think this court can support. Because after the fact, Mr. Greenbank decides, realizes, or for whatever motive or reason, that, look, I never intended to include this retirement, but you never raised it to the attention of the other. Parties entering into a contract have duties to disclose material information, and this happened to go in writing to confirm that and keep it up to date.
What are we supposed to do with the corporate form question that this asset that was producing income was not owned by Mr. Greenbank, but was in fact owned by an LLC, and therefore wasn't his to, and clearly I think the language said that it that asset couldn't transfer any other assets. What are we to do? Are we just to kind of sweep away that there was a corporate form there that had, and I think that's what the court below talks about. You can't just take away that an LLC owned that. You didn't say, he's not the owner of that. So what are we to do with that? What was the lower court to do?
Well, the record demonstrates that Mr. Greenbank was the owner, the sole owner of Energetics, and Energetics then was involved in the profit plan, as you point out. So it's a matter of Mr. Greenbank's investments in Energetics that lead to the plan that generates money for what purpose? To help, and maybe it's retirement or not, but it helps fund the settlement agreement. It comes to Mr. Greenbank, and it's an investment. He has an investment in Energetics. Energetics has its investments. But the point is, it all flows back to Mr. Greenbank, so it would be available for payment under the settlement agreement.
But that would be the case in any LLC, that if you're saying who the ultimate recipient is of a benefit, that may be personal, but it's still shielded in the form of an LLC, and that has meaning in Arizona, doesn't it? Absolutely
it does, but in the LLC context, the tax laws are set up to have the individual owners, like a sub-S corporation and like a partnership, report the proceeds, the income that they get on their personal return. So even that supports the fact that this is still a pass-through situation back to Mr. Greenbank, who's responsible after he had some problems and taking money maybe he shouldn't have, to pay off his debt.
Thank you.
I think as we come back and look at where the line in the law is drawn and apply it in this case, we can see that contracts matter, that the terms of a contract matter, and the plain meaning that we all associate should be enforced in this case and not require people, especially unsophisticated people or people in commerce that are not helped by lawyers, to take away something other than what red means. Does red mean red? Well, maybe red can be susceptible to more definitions because there's 50 shades of red. But the common person entering into agreement and attorneys doing these kinds of things shouldn't be required to ask an infinite set of questions with respect to this situation. So when we turn to start examining more carefully Taylor and the laws of construction, we can say this is an unambiguous situation. You may want to do that there is clear words that are used that need to be given their meaning. But what you can't enforce is say all investments versus the secret intent that's not even enforced under the law. That's something that cannot be done. It would lead to problems in contracting and other interpretations, and even ambiguous matters that are undisclosed. The law says, as we cited on page 21, that you shouldn't consider admissible evidence. You should judge by objective standards, because that's what people do in entering into their contracts. They don't guess or speculate or say, by the way, Mr. Greenbank, does all investments to you mean all investments like it does to me? And discuss that type of thing. It's nonsensical to think that someone would have to do that for so many clauses in a particular agreement. So the objective intent, not the hidden intent under the law, is what's enforced. You can't support secret intention. And then there becomes the idea we have to look at the parole evidence rule eventually and jump into taking a look at what these Taylor standards really require, of this court as it did earlier courts. Does step one, the evidence aid, because you don't have to prove ambiguity anymore under the Corbin view and is adopted in Taylor. So let's take a look at the evidence. Does it aid in interpretation? Well, does the word all need interpretation? Does the word investments need interpretation? In paragraph 9, which you mentioned earlier, there's comments about any of the investments. Those are the words there as well. That may also help, give us some understanding and meaning. So can we stop right there? Is this a situation that is so unreasonable and extraordinary that's in an improbable situation? I'm not here to say all investments goes that far. But what is made clear in Taylor is that you can't turn white into black, and you can't say $1 means 50 cents. But that's what's going on here. All is now something less than all, and investments like money in a profit-sharing plan that pays out through a passive investment to Greenbank that becomes his money that should be paid to Bonnie 1/2 falls into that white versus black situation.
So the court was wrong in finding that the difference between the language in paragraph 8 and paragraph 9 could be ambiguous. They were wrong to make that initial finding, to get into what the difference may have been between investment and other assets?
Yes, I think the court was wrong because it decided to take the extrinsic evidence, and they were wrong when they determined and failed at the second step of Taylor, which is really concluding that extrinsic evidence will be looked at and does not vary the terms of the agreement. That's the point of contention, I think. By the time you boil it down, did the underlying court interpret this by making the consideration that, well, when I say that's reasonably susceptible to different interpretations, those words primarily in Exhibit 8 that they rely on, of all investments, that means there is obviously something there that does not contradict the true meaning of the written words. And what was it? Well, we don't really know. I don't think it's clear from the record, but it's your opportunity now to re-examine and apply your own contract interpretation here. But here, by going through this process, which I think the court is required to do, there is a different result, more like the first judge. But I think the different result here, when you examine what the wording is and say, is this really something that's confusing beyond the ordinary meaning? I'll take a look at that extrinsic evidence, but does it help me explain, like the word used in Taylor, or is this something that's changing a meaning of all? Red means red, all means something less than all. White cannot be turned into black, but I think that's really what's going on here. And that's why I got to urge you to take a look at not only this case in a settlement agreement, but perhaps maybe the bigger picture. Is it appropriate to support a undisclosed intent at the time of contracting? No. There's different laws in different areas around contracts that say no. We cite to the contract interpretation situation. You can't do it, and you shouldn't do it. And that's why I think you can walk through, and by the time you get through the Taylor test, I think you have an opportunity to say, yeah, we're going to understand and support the ordinary meaning in this settlement agreement. Courts generally try to support the meaning in settlement agreements to enforce their terms, to hold them in place. Similarly, I think there's still this breach of contract that sits out there with respect to the affidavits that were required. There just wasn't a production of accurate and timely affidavits. That's something else under a different standard, but there is things like Mortgages Limited was not in there. The court noted this in its finding. There's other assets that sit out there. And I still think that my client should be put at least on par in that other asset category that should have been listed. Where are bank accounts? They're not even on there. And so other creditors get to go after bank accounts. One of the findings in the earlier court versions was that there is, you can get the distributions of the profit plan after it comes out and gets over to Mr. Greenbank. In closing at this moment, I'd like to leave a few more minutes for rebuttal. This situation, I think, is curable with respect to the law getting down to the point where you will apply it to enforce the proper objectives of accounting and in mutual intent at the time of contracting. Thank you. I'll stop there for now.
Sure, thank you. When you're ready. Counsel, if you'd stay at your podium, I'm sorry, I should have mentioned that. That's kind of our protocol right now. I appreciate it.
It's the only way we can capture on the microphone.
Yep, that's where the mic is.
Good morning.
Thank you, good morning.
Tim Barnes on behalf of the appellees. We were cross appellants as well, but we did not file a brief and are not pursuing our cross appeal. I'm first of all overwhelmed that I'm standing here in person because it's been since February 19th of 2020 that I was last in person in front of a court. I've had a lot of trials, a lot of evidentiary hearings, a lot of arguments, and none in person, and I am grateful for this opportunity. As you can tell by my hair, I've been doing it a while, and I appreciate this as opposed to being online. Where to start? And I have not planned an argument as such because I wanted to hear what Mr. Royal had to say and focus on that. And where I've decided I need to start is what caused this dispute in the first instance. And that was Ms. Van Zandt accusing Mr. Greenbank of keeping money that was her money in an investment they had together called Silverdove Properties, LLC. And the members of Silverdove Properties, LLC were Ms. Van Zandt's profit-sharing plan, which is the plaintiff in this action, and ERPSP. It's easier to say ERPSP than Energetics revised profit-sharing plan. So she knew from 1994 when that entity was formed that ERPSP was out there and that it was investing. Those were not shared investments with ERPSP and Ms. Van Zandt's profit-sharing plan, but she was aware that ERPSP was making investments. I start with that. Second, we hear that Mr. Greenbank had some duty or obligation to disclose certain things. Well, that presupposed that there was negotiations that went on, and there were not. There's no evidence of that. In fact, the evidence is just the opposite. There were no negotiations. The agreement was drafted by Ms. Van Zant's counsel, presented to Mr. Greenbank to sign, and he did not speak to anyone about what this document meant. He didn't speak to Ms. Van Zant, that's undisputed. He didn't speak to plaintiff's counsel who drafted the document. He just was presented with this document and said, read it and sign it, which he did. Now, we hear this notion of the words are plain. Well, they are plain. And the word all is it's a great pronoun. It means all of them. But all of what? And we know, counsel said, well, we know what the word investments mean. We don't need to interpret that. Well, actually you do. Because investments in this instance is a defined term. And that defined term says that we are considering investments that John, in paragraph 8, in the first sentence of paragraph 8, is referred to as John, and the second time he's referred to as Greenbank's investments. So the investments is defined to mean those investments that are placed on an affidavit which was created after the fact and then attached to the document as Exhibit B to the document. Now, Ms. Van Zant was fully aware of ERPSP. She had intimate knowledge of it. She was accusing ERPSP of keeping money, or John, on behalf of ERPSP, keeping money that was hers. So then you get down to, well, how do we interpret the word investments, or the phrase, I shouldn't say interpret the word investments, I don't mean that, Your Honors. What I mean is that sentence. And that sentence is quintessential Taylor versus State Farm. I remember during our case when they first came out, and I scratched my head and read about it and said, well, this must only apply to insurance companies and insurance contracts. And then, of course, in 93, Taylor versus State Farm came out, and there was a full explanation. And since that, there's been a robust interpretation of what Taylor versus State Farm means. Robust. And what it comes down to is this. And there's two cases I cited in my brief, the Lennar case and the Long case. And in the Lennar case, it was a question of whether or not a particular party was an additional insured or was supposed to be an additional insured on an insurance policy. It was a construction case. And there was no reference to requirement of an additional insured. And so the Lennar case said in the particular construction contract that required insurance, that the sub or the general, I can't recall which now, whether it was a sub or a general, went out. I believe it might have been a sub. And that somehow there was some question as to whether the general should have been an additional insured and covered under that policy. And the court said, look, there's no language in this construction contract that helps us understand what insurance you're supposed to get or whether you're supposed to name somebody as an additional insured, and therefore that clause is not reasonably susceptible to more than one interpretation. And then you go to the Long case, which is Long versus the City of Glendale, and that case involved John F. Long had donated land to the City of Glendale, the City of Glendale to use as an airport. And the second, there was a question in there was a settlement agreement that John F. Long said meant that the city was supposed to construct a second runway. And the Court of Appeals said, this court said, look, there's no reference to the runway in that settlement agreement, and therefore it cannot be reasonably susceptible to that interpretation. And that's what I'm suggesting to this court is the reason why the absence of ERPSP in paragraph 8 or 9 for that matter, but really it had to be an 8. The absence of ERPSP means it is not reasonably susceptible to interpret John and then Greenbank's investments to include something that is not identified, namely ERPSP. And I go so far as to suggest to the court that the argument that ERPSP should be included is parole evidence. Because if we look at the plain words of this particular phrase, there's no reference to ERPSP. And if you look at the plain words, it's self-contained to say it should be, and I'll read it, if I may, just the first sentence. Contemporaneously with the execution of this agreement, John shall execute a sworn and verified affidavit detailing a full and complete list of Greenbank's investments. And then that's defined as investments. Now, I was not particularly skilled when I was in high school at diagramming sentences. And I'm still not particularly skilled at it, but there's an app out there that will tell us. You put the sentence in there and it'll tell you. And we know that the word John is the subject of this clause because it's saying, John shall. And we know that the verb he's supposed to do is shall execute. So John is supposed to execute. And then the direct object of what John is supposed to execute is the affidavit. And you don't get down to the list, which is another direct object, but Greenbank's investments is just a noun. It's just a noun. So my point is this. The only reason that when the parties to this action talk about all investments and they don't reference ERPSP, everybody in that room understands that ERPSP is out there. The question is whether or not that's intended to be an investment that should be listed. And there is no duty to disclose ERPSP because, again, everybody in the room knows it. In the room vis-a-vis the contract that hasn't been negotiated, that's just been presented. So Mr. Greenbank has no real opportunity to understand, well, what do you mean by that? And all Mr. Greenbank has is not an undisclosed intent. It was never asked for, just as Ms. Van Zandt's intent was never given to Mr. Greenbank. And so what we have is a situation in which Mr. Greenbank is left to understand, well, what does this mean? And it says, John shall execute an affidavit of Greenbank's investments. And ERPSP is not one of John's investments. It is not legally. It is owned by Energetics Inc., which created the profit sharing plan. And we know that Arizona has long said, as do every state, that entities, corporate entities, whether they're LLCs or otherwise, are distinct entities separate and apart from the owners of those entities. And the same is true of a profit sharing plan. A profit sharing plan under the ERISA law can sue and be subject to suit. So an action can be brought against ERPSP as well. So to suggest that somehow this is John's investment, when in fact John doesn't own it. John does own ERPSP, but everybody in the room knew that to begin with, and if that was everyone's intention, it should have been more clear in terms of how it was drafted. The parole evidence rule doesn't come into play here, respectfully, because John simply expressed in court, this was what I understood, and no one gave me any information otherwise to believe it should be something other than that. So that's not parole evidence. That's his understanding. That's his intent. And his testimony was, I'm not going to put up my retirement plan and allow that to be taken. Now, Ms. Van Zandt testified that yes, that was her intention, but that intention was never communicated. So therefore, that intention is quintessential It is parole evidence, but it's not, because ERPSP is not reasonably susceptible interpretation of paragraph 8, the first sentence, then it's improper parole evidence and should not be considered. And unless the court has any other questions.
Well, Counsel, what weight do we give to the fact that Exhibit B does list some of ERPSP's investments?
It does list one or two, but it does not list ERPSP as such, number one. And number two, Your Honor, one of those examples is Traverse Mountain. Traverse Mountain, but there were two Traverse Mountain investments, one for ERPSP and one for Mr. Greenbank individually. And then Mr. Greenbank sold a portion of that Traverse Mountain investment to his wife, and so she was receiving payments for that. So it's not ERPSP per se, it's simply an investment that ERPSP had in fact made.
All right, thank you.
And how is that different from his profit sharing plan that's owned by the same company?
Well, Your Honor, Mr. Greenbank's testimony in trial was, look, I listed that. I didn't mean to, but at the same time, I knew I was getting money from that. He knew that Bonnie was getting money from that as well, so he listed it.
So there's no difference. There was an investment that was wholly owned by the company.
Well,
he was receiving payments for. One he didn't list at all, and one he listed but testified that was mistaken. Am I summarizing that correctly?
Yeah, yes, it was essentially more than one investment in the sense that ERPSP owned some of it, Mr. Greenbank owned some of it, and then he sold some of his to Ms. Van Zandt.
So you're saying the interest that the company and Mr. Greenbank had together was the only, because when you started you said there were two different.
When he originally made the investment, there was Traverse Mountain. It's also called another one that suddenly I can't really recall. It was a project in Utah. But Traverse Mountain was originally invested in by both Mr. Greenbank individually and by Energetics, Inc., not Energetics Profit Sharing Plan, but Energetics, Inc., and by the Profit Sharing Plan.
All three of them?
Yes.
Went in together?
Say it again, I'm sorry.
All three, so Mr. Greenbank, Energetics, Profit Sharing, and Energetics?
Well, Ms. Van Zandt did not originally invest in it. She did not. It was just Mr. Greenbank. Mr. Greenbank then sold a portion to her.
Okay. I'm just trying to figure out, Traverse Mountain is owned jointly initially by Mr. Greenbank, the Profit Sharing Plan, and Energetics as a company?
Not really jointly. They were separate investments. There were separate payments made by each. And then Ms. Van Zandt, when hers was, Mr. Greenbank also sold off a portion of his investment or Energetics investment over to another relative of his. So
but
all
at
of
the
those
time
were
that
separate.
he filled out the affidavit, he still had an individual ownership of Traverse Mountain?
He did.
Oh, and you're saying that's what he reported?
Well, Your Honor, it's not clear what he's reporting, whether he's reporting that versus everything else. I don't recall, to be very blunt, the specifics of how much the percentage is here. How much of that was just Mr. Greenbank's or just Energetics.
Okay. Thank you.
Thank you.
The way this agreement was set up by the parties was to put the obligation on John Greenbank to report his investments. And that, as pointed out, that is the definition. Mr. Greenbank is the only one that knows the status of his investments at the time. So Silverdove and Bonnie had to rely upon John's affidavit. It just turned out not to be accurate. And it did have, contained on Exhibit B as pointed out, some investments from the profit plan / energetics that delivered the message and delivers the interpretation that Bonnie had to accept, and it turned out to be wrong. So some of these investments on Exhibit B did exist, but were not complete. Some were wrong, admittedly wrong, etc. And so this is what is required for Silverdove entering into this agreement. A couple other points here is that Mr. Greenbank did have the opportunity to comment on the agreement, and he did on paragraph 7, and that got changed. That's set forth on page 11 of our brief. And we agree, as pointed out by counsel, that there is plain meaning attached to these words. And then finally, the cases are really, in my view, not helpful because it's still an independent case-by-case determination. We put one case in, the Markham contracting case, in which there was a finding in which the clear meaning won out over the secretive intent. So thank you very much for your time. I appreciate it.
All right, thank you. Counsel, thank you for your arguments. We'll take this matter under advisement and issue our decision in due course, and at this time, the court is adjourned.